So let's say you are a songwriter, you're an artist, you come up with an idea then royalties come to you, right? That's the way it works. But what about AI? AI is now making music. AI is now making art and other things. What about corporate inventions that AI comes up with? It happens. Who gets that money and whose license? Can a robot actually hold a patent? It sounds weird to ask that question, but it's a legit question. And we're going to find out with the patent professor, the adjunct professor of patent law at Nova Southeastern Law School. And he's written a couple of books on patents. His name is John Rizvi, the patent professor. He's with us now. Hey, John, good morning.
Yeah, good morning. Always a pleasure to be here.
I love talking patents and inventions and entrepreneurship and all of that kind of stuff. I have a couple of ideas myself, but the big deal here is, what about creating books and music and art? AI is doing all of that now. Who gets that money?
Yeah, so the question becomes, and you say AI is doing it, but those proponents that say that the authors, the human beings, should be entitled to it, their claim is that AI is just a tool, no different than a camera might be for a photographer. So we don't take the copyrights away from a photographer that takes a photograph and he uses a tool, or a painter uses a paintbrush and a sculptor uses a chisel. So the argument is that, hey, AI is just another tool. The problem is this is not just another tool. It's incredibly powerful, and the contribution of the human being is less and less the better these robots get. And that's where the problem is going to become. I mean, and you're not that far off in that at some point the contribution of the human being to the final output is going to be so minuscule that pretty much the piece of art would be deemed created by the computer. And the problem that the reason that's an issue is that under the Constitution, copyrights and patents are limited to human beings, and the Supreme Court has even upheld that. There's a recent monkey selfie case where a monkey got a hold of a cell phone and took a bunch of pictures, and they held that a monkey cannot have the rights to a copyright, and neither can a computer.
Oh, that's funny. So the owner of the cell phone gets the copyright to that, then, I would think, right?
Yeah. So, well, he's not the author either. It's a minefield. I mean, it's tough. There's ownership, who owns it, and then who's the right author. The same issues are coming up with computers as well. Is it the person that developed the AI program that was used, or is it the person that entered the prompt? As of now, the Patent Office has issued guidance that and I don't know how much guidance it is that the contribution has to be significant. Now, what's significant? That's where the courts are going to have to decide, and we're going to have case law that helps illuminate how much contribution is enough to entitle someone to be an inventor.
This is, you know what, when you were in school, again, learning to be the patent professor, you had no idea we were going to get into all of this. Patent lawyers had no idea. Who knows where this lands? And here's the thing, we can have fun with monkey pictures, we can have fun with songs and artwork and stuff, but there's billions of dollars at stake in this, in corporate investments and stuff, isn't there?
Yeah, 100%. And for businesses, they need to know, investors, they need to know who owns the intellectual property in order for, prior to investing. And that right now, there's a huge gray area as to whether it's even protectable and where the ownership is going to lie and who the author is going to be considered. Because if the author is not a human being, or the inventor is not seen to be a human being, there's currently no intellectual property for computer-generated or robot-generated art or inventions.
How far away are we from some concrete answers? That doesn't seem like we're ever going to be able to get them.
Yeah, so, I mean, there was hope. In October, President Biden issued an executive order asking the Patent Office to publish guidance. There's a lot of hope that the guidance we received would provide the answers, but unfortunately the guidance was that the contribution needs to be significant. And that's not very much guidance, right? So we're left back to the drawing board in terms of trying to figure this out. I don't think there's going to be clarity until we get more cases, and that's really what determines how much is going to be enough. And eventually, I think Congress is going to have to step in with new laws that illuminate authorship and inventorship for AI-generated works.
All right. John Rizvi is the patent professor. Look him up. Where do we find you? Tell everybody your website there, John.
Yeah, so the website is thepatentprofessor.com, and in fact, anywhere on social media, that's our handle. So Facebook, Instagram, Twitter, just type in The Patent Professor, and you'll find us.
What I like about you is you put this in regular, everyday talk to normal people. Because people, what they want to invent something, how often do you think, give me a percentage, this is your judgment here, but somebody comes up with an idea, and then it turns out, nope, it's already done. That happens to me all the time.
That's fairly common. The first thing we do is a patent search to make sure that the idea is new. And unfortunately, a lot of times we'll find that someone's done something close, and then our team can try to help to see if the difference is enough to justify proceeding with a patent. A lot of times it's not.
Does your team work on, and do you work on stuff like licensing? Like The Rock just licensed a bunch of his stuff. Like he can be called The Rock now and all of that. Do you license that kind of thing? Do you work on that?
We do.
Yeah.
Everything relating to owning an idea or a brand, that's all within our expertise at the firm. So protecting ideas, protecting brands, licensing those ideas and brands, that's all covered. It's getting trickier as these new issues come up, and you're right, this isn't something that any patent attorneys are really prepared for.
You're going to love this. You know what? I am the Groovener. At the end of my show, I do groovy news. I'm not the governor. I'm the Groovener. I've already protected that. I am the guy.
That's terrific.
Huh? Come
Terrific.
on. All right. The other thing I have to before I let you go, I recycle Ziploc baggies. You know, the little sandwich bags? We use those over and over again. I invented a drying rack for after you wash them, you hang them up and they dry. I'm calling you on this, okay? I'm going to have your work on this for me.
Of course. Got to get that protected. Remember, if you reveal it publicly, like drawings or anything, you have, then it's really a race to get your patent in first. The U.S. has moved to a first-to-file system. Whoever files the application first owns it, so the timing's critical. So keep it confidential until we're ready to get this protected.
Somebody told me, though, if you use it in commerce first, does that count?
That will help protect the brand. So if you use it in commerce, then you can get a trademark. That's if you give it a special name, similar to the Groovener, if you come up with something for the Ziploc bag dryer. A snappy name using it in commerce helps you secure that. However, as far as protecting the idea itself, there's really no substitute for filing that patent as soon as you can.
Buddy, I'm on it. You and me, we're going to be Ziploc bag dryer rich. Huh? How about that? All right.
That sounds good.
He is the patent professor. Really, no, AI is a minefield, and we'll keep our eyes on this. Thank you for following us for us. Find him, the patent professor, on the web, John Rizvi. It's always a good time talking to you, buddy. We'll talk to you later.
Thank you. Always a pleasure.